So, what if I told you that doing something that looks exactly like a crime, pulling a trigger, causing an accident, breaking into a house, isn't always, a crime in the eyes of the law? It sounds kind of crazy, right? But our legal system is built on this really fascinating idea. Not every harmful act is a criminal one. And in this explainer, we're going to dive deep into the 13 legal shields under India's new criminal code that can turn what seems like a crime into a total non-offense.
Here's the deal. Under the Bharatiya Nyaya Sanhita, or BNS, there are 13 general exceptions that can shield a person from criminal liability. Now, don't think of these as get-out-of-jail-free cards. It's more like the law recognizing that context, your intention, and your state of mind, well, they're everything. We're going to break down every single one of these 13 shields so you can really get them and remember them.
And to make this super simple, we've grouped these defenses into 5 clear categories. We'll start with honest mistakes, then get into situations where a person isn't really in control of their actions. After that, we'll look at acts done for a greater good, then cases of force and authority, and finally, we'll cover your fundamental right to defend yourself. All right, let's jump right into our first category. This one covers situations where there was simply no criminal intention. These are what you could call the oops defenses, for when things go wrong even though you had the best intentions. Starting with a simple honest mistake. Okay, so under sections 14 and 17, we have something called mistake of fact. Now listen, this is really important. Not knowing the law is never an excuse. This defense is about being mistaken about a key fact in the situation. You genuinely thought you were doing the right thing, that you were legally justified, but you were just acting on bad information. And this example makes it crystal clear. The police officer has a legal order to arrest person Y. They do their homework, but they make an honest mistake and arrest person Z, truly believing it's Y. Because it was a mistake of fact, made in good faith, the law says the officer is protected. It wasn't a crime. Next up, under Section 18, is accident. This one is pretty straightforward. It boils down to a simple checklist. 1, you were doing something legal. 2, you were doing it in a legal way. And 3, you were being reasonably careful. If you can tick all 3 of those boxes and something still goes terribly wrong, the law sees it as a true accident, not a crime. So what's the difference between a tragic accident and a crime here? Well, it all hangs on those 2 little words, proper caution. If the person was just swinging that hatchet around recklessly near people, that's not an accident, that's negligence. But if they were being careful and the tool just failed, the law sees it as a legally excusable tragedy. Okay, so we've looked at when you didn't intend for something bad to happen, but what if a person is legally seen as being completely incapable of forming a criminal intent in the first place? Well, that brings us to our second category, capacity. This is fascinating. The law draws some really clear lines here. For example, check this out. Under Section 20, a child under 7 years old is legally incapable of committing a crime. End of story. From 7 to 12, it depends on whether they were mature enough to understand what they were doing. With insanity, the test is whether they could know their act was wrong. And notice that last one. Being drunk is only a defense if it was involuntary, meaning someone did it to you against your will. The one big idea that connects all of these defenses is a legal concept called mens rea, which basically means the guilty mind. Think of it like this. A crime needs 2 things, the guilty act and the guilty mind. These 4 defenses all argue that because of age, mental state, or forced intoxication, the person's mind just wasn't guilty. They couldn't form that criminal intent. Okay, let's shift gears a bit. So far, we've been talking about excuses, things like mistakes and not having the capacity to commit a crime. Now we're moving into justifications. This is when someone knows they're doing something harmful, but they do it for a really good reason, like preventing an even bigger disaster. This is the classic lesser of 2 evils defense, and it's covered in Section 19. The law is practical. It recognizes that in a crisis, you might have to break a rule to save lives or property. The absolute key here is that your goal wasn't to commit a crime. It was to stop something much, much worse from happening. And this example, wow, it's intense, but it illustrates the point perfectly. The captain is stuck in an absolutely impossible situation. By acting in good faith to save the bigger group of people, the law justifies the tragic but necessary harm he caused to the smaller group. Now, let's talk about a defense that's kind of related to this idea of accepting a risk for a good reason, consent. If someone willingly agrees to let you do something that might be harmful, can you be held responsible if it goes wrong? The answer? Well, it's complicated. See, the law doesn't see consent as just one thing. It sees it in layers. Section 25 covers general consent, like in sports.
You agree to play, you accept the normal risks. Section 26 is about consenting to something for your own good, like surgery. And Section 27 is for when a guardian has to consent for someone who can't, like a child. In every case, a harm is risked, but it's for a justifiable reason. Okay, but we need to be absolutely 100% crystal clear on this one point, based on Section 28. Consent that's given because someone is scared or because they've been tricked or lied to is not real consent. It's the foundation of this entire defense. If it's not given freely and with full knowledge, this defense is completely off the table. Period. So what happens when it's not really your choice at all? Our fourth category is all about external pressures. What does the law say when you're either just following a lawful order or you're facing an unlawful, deadly threat? This slide shows two sides of the same coin, really. On the one hand, you've got acts done under legal authority, a judge handing down a sentence, an officer carrying it out. That's all protected. But on the other side, you have compulsion, which is a defense for an ordinary person who's forced to do something wrong because of an illegal threat of death. Now, the defense of compulsion is only for the most extreme situations imaginable. We're not talking about a threat of just getting hurt. The threat has to be of instant death. In this example, the blacksmith isn't helping the robbers. He's a victim, acting under an insane amount of duress. So the law says you can't hold him responsible for that. And now we've arrived at our final category, and it's probably the one that gets talked about the most. This is all about the fundamental right to protect yourself, other people, and your property from harm. This is the million-dollar question, isn't it? Everybody has the right to defend themselves, but, and this is a big but, that right is not unlimited. The law draws some very specific lines about when you're allowed to fight back and exactly how much force you're justified in using. And under Section 38, the law gets incredibly specific. It says you can use force, even deadly force, but only when you are facing the absolute most severe threats. We're talking about a reasonable fear of being killed or seriously injured, or facing threats like rape, kidnapping, or an acid attack. In these truly dire situations, your right to defend yourself is absolute. Whew, so there you have it. From genuine mistakes and impossible choices, all the way to your right to fight back, we've covered the 13 legal shields in the bands. And if there's one common thread through all of them, it's this. The law always tries to look beyond the act itself. It looks at the intention, the circumstances, and the person's state of mind. It's a powerful reminder that real justice always requires context. In the end, these defenses are there to be shields for the innocent, the mistaken, and the coerced. They're not meant to be swords or loopholes for the guilty. And they force us to ask a really tough question, not just about our legal system, but about our society. How do we balance getting justice for victims with showing mercy for those who acted without a guilty mind? There's no simple answer to that.